This is the CitizenLink Report.
If you find our insights helpful, would you support our video efforts? Your gift of $25 or more goes a long ways. Covers the crew, lights, cameras, all that. Just click on Donate. Thanks from all of us. Most of what you're hearing in the mainstream media is badly misrepresenting what the Supreme Court actually decided in the marriage cases. We'll sort it out for you from a Christian conservative perspective. This is the CitizenLink Report. Hi, I'm Stuart Shepard, along with Bruce Hausknecht, who follows the courts for us. Hi, Bruce.
Hi, Stuart.
At first, let's talk about what the Supreme Court did not do. What did they not do?
Right. Out of the two cases that came down today on marriage, the Prop 8 and the federal DOMA case, we did not get a sweeping 50-state mandate that same-sex marriage must be the law of the land, similar to the Roe versus Wade that imposed a whole new social agenda on America. We did not get that. And similarly, because we didn't get that, we also didn't get any kind of decision saying that same-sex marriage is a civil right guaranteed under the federal Constitution. That's important to know going forward.
So they did not find magically discovering a right to same-sex marriage in the Constitution. And that's actually good news from our side. I mean, that would have been the worst case scenario.
It really is. I mean, the rest of the decisions really get lost in the legal weeds here. And you have Anthony Kennedy involved again, which always creates frustration and complexity where none should really exist. And so there's a lot to talk about.
Okay, let's talk about the two cases. We'll do them one at a time. First, the headlines are saying that the Supreme Court struck down the Defense of Marriage Act. That's true in part, but the part that was left is significant.
Yeah, DOMA essentially has two key parts. One is the definition of marriage for all federal law purposes, for administering Social Security or marriages in the military benefits, that kind of thing. The other part of DOMA is that no state in the Union shall be required to recognize a same-sex marriage that's legal in any other state. So there's a protection for the states. That particular protection was not challenged in this case, not affected by this decision.
Now, my understanding is that the way that Kennedy wrote the opinion on this may have actually strengthened that protection of one state from another as far as being forced to recognize same-sex marriages when a state has already passed, say, a marriage protection amendment.
Well, that's true, because for many pages in his decision, he went on about the state's right to define marriage and the historic protection that the federal government has given to states to define their own marriage laws. So inadvertently, while striking down one section of DOMA, he's strengthening the state protection against recognizing same-sex marriages.
So this is going to place a lot of emphasis on what happens at the state level yet again.
That's what we're hoping.
Now, and I was going to say, we're not saying this is a good decision. We think the Supreme Court got it wrong, but the part that's left is highly significant and worth talking about.
Yes, and it did get it wrong, because the federal government has federal laws. It's entitled to define the terms in its own laws and the benefits that it gives based on you and I as taxpayers paying into the general pool. We know that Congress has an interest in marriage because they've been legislating about it for a couple hundred years. You'll remember from your history books that in the 1800s, Congress passed a law requiring some states, well, like Utah and Arizona, as territories, to include a prohibition of polygamy in their state constitutions before they would be allowed into the Union. So Congress has been legislating about marriage and defining marriage for a long time.
Now let's talk about the second case. This one we also, our opinion is the Supreme Court got it wrong on this one as well, but for different reasons. And it's a little more complicated, but if you take a moment to walk with us through what actually happened, we think it'll help you when you have conversations about this to have the proper insights on it. This is the California Marriage Amendment, also known as Prop 8. The court effectively said what?
Well, it effectively said, we don't have the jurisdiction to even hear this appeal, so we are dismissing it, and we are also dismissing the decision from the Ninth Circuit Court of Appeals.
Which means it's as if it never happened.
As if it never happened. So the decision goes back all the way to the trial court's decision from 2010, Judge Vaughn Walker, now retired. That's, in short, what it what it says, but what it means
Yeah,
is
what does it do?
going to be the subject for a lot of debate over the next days, weeks, and months.
And that's because?
Well, because no one is quite certain what Judge Walker's decision actually means legally. He wrote an order that says, I'm telling the state of California, you must recognize same-sex marriage. But he did not have the entire state before him in terms of a class action suit. He did not have all of the county clerks involved. He had 2 county clerks involved as defendants, a couple of the state officials, governor and the attorney general. So is he entitled to, under those set of circumstances, is he entitled to bind the whole state? There's an issue there.
So if I may summarize, just to help us out here, one interpretation of this would be that it only applies to the folks who came before his court and said, this hurt us. So it could be that just the 2 couples who complained, who brought the complaint to the court, could be the only ones who are covered by this?
That's exactly right. And now there's another issue here, in that the California Constitution has a provision, apparently, that says that no duly enacted law in the state of California can be disregarded by state officials unless an appellate court has struck it down.
But we just said that the Ninth Circuit Court of Appeals was as if it never happened.
As if it never happened. So we do not have an appellate court striking down Prop 8. So given what the California Constitution says, Prop 8 is still in effect unless and until we get another appellate court to strike it down.
Now, I have to mention that the headlines are saying California will start issuing same-sex marriage licenses. Could happen very quickly here, and we're seeing those pronouncements. But that's going to be challenged pretty quickly in court by those who say, hey, hold on a minute, not so fast.
I would expect some of those county clerks to resist such an order, and we'll be back in court. Maybe state court this time, not federal court, but it will quickly turn into more litigation.
Now, we're going to get into the weeds just a little bit. If you follow with this will be worthwhile, I think. We'll talk about it. This sets up a very strange situation back at the district court level about, you mentioned that it would have to go to the appeals court in order to overturn Prop 8 for the entire state. Mm-hmm. Who would appeal it to the appeals court in this case?
Well,
because the folks who brought the case initially won, so they can't appeal it up.
That's correct. And the time for appeal of that decision is over. So what we're talking about is it would have to be a totally new lawsuit. Maybe this will happen. California governor issues an order saying all county clerks must start issuing same-sex marriage licenses. A county clerk files suit saying, I object.
I'm bound by Prop 8.
Prop 8 and the California Constitution tell me that I have to enforce Prop 8. I can't enforce your order. And so he goes to court. And we're going to have a court decision, and if that decision gets carried up to an appellate court, state or federal, then and only then would there be a ruling that would be binding here if it strikes down Prop 8.
All right. Let me ask you this just as we wrap it up. What's ahead? What happens next? We've talked about some of the alternatives, but as you look across the whole thing, what do we see?
Well, here's what we've got at the end of the day. Marriage is still a state issue. It has not been taken over by the Supreme Court or the federal government or made a federal constitutional issue. So states still have an interest in defining marriage. They still have an interest in protecting children by giving them the very best possible environment for growing up, which is a man and a woman united for life. And that's where we're at. So it's back to the states. And we'll see more litigation based on both of these cases very soon.
We've often said that no matter which way this went, the other side would not go away. They would keep pursuing this. Guess what? We're going to stay in this fight as well.
Amen.
All right. Thank you, Bruce. Appreciate your insights. Appreciate you for joining us here. We hope that was helpful in understanding what just happened at the Supreme Court level. We encourage you to pray for our elected officials, but also pray for those groups around the country that are standing tall for marriage, that are saying marriage is the union of a man and a woman, and redefining it is not something that the nation wants. Pray for those organizations. Support them if you would. Help them to maintain this fight out there state by state across the country. And remember, stand tall and be heard.